Hello everyone, thank you for watching this video. My name is Santiago Padilla and I am an immigration lawyer in Miami, Florida. I've been practicing law now for over 30 years and my focus in the immigration law field is business visas, investor visas, basically employment-based immigration. In this short video, I want to give you a summary of the E-2 Treaty Investor Visa. This is a very popular and useful visa for persons that come from a country that have a treaty with the United States. These are called treaties of navigation and friendship. Countries that have such a treaty with the U.S. include Argentina, Canada, Mexico, Colombia, Chile, Ecuador, several European countries, for example, Spain, Germany, England, Italy, Poland, etc. There are many other countries, I'm just naming a few. But this visa permits the foreign national, the citizen of the foreign country, to come and live and work in the U.S., usually for 5-year periods. And that 5-year period, or whatever period is granted, usually 5 years, can be extended indefinitely. It's almost like being a U.S. resident. All right, these are the requirements for the visa. It has multiple parts, and first I'll enumerate the requirements, and then I'll explain each one. First, the investor must invest a substantial amount of capital. Second, that capital must be invested in a U.S. enterprise. Third, the investor must come to the U.S. to manage the investment and the U.S. enterprise. And fourth, the business cannot be marginal or passive. Now, let me go through each one of these and explain what they mean. First, a substantial amount of money. What does that mean? That means a lot of money that must be invested in the U.S. enterprise. The law does not have a fixed amount, but we know from experience that about $150,000 to $200,000 investment will suffice. Second, the investor must come to the U.S., invest that money in a U.S. enterprise. That means a U.S. company. That means a going concern or a company that will be a going concern soon. What investors usually do is they purchase a going business that is being sold, and that is sufficient. Third, the investor must come to the U.S. to manage that investment in the U.S. enterprise. That means that the investor must be on the management team of the company and must earn a salary. Finally, the business cannot be marginal or passive. What does marginal mean? Marginal means that the business gives off enough money only to pay the salary of the investor. It has no employees. That's marginal, and that's not allowed. And second, passive means that the business does not have daily activity. That is just a business that rents properties, for example. A real estate investment could work, but the investment would need to be structured in such a manner that it's not passive. In other subsequent videos, I'm going to give examples of how this can be done with real estate investments. But suffice it to say for now that the business cannot be marginal or passive. Well, that's it. Those are the requirements. I think it's fairly simple. Obviously, the detail is really important in this aspect. I hope this explanation is helpful. And if you have any questions, please call me at 305-824-2400. Or you can send me an email at sjp@padillalawoffice.com. Thanks for watching. Bye-bye.